Welcome! During this video, you will learn how to start a divorce or legal separation case in Santa Clara County, California. There are multiple videos you will watch. This first one lays the groundwork for how to open a divorce case and to see whether or not you qualify to start one in this county. Before starting, you must make sure that you qualify to start a divorce case. There are some situations that might disqualify you or complicate your case, including if you have filed for divorce in the last 5 years, even if you filed outside of California, if your spouse has already started a divorce case against you, or if you or your spouse was still legally married to someone else at the time of your marriage to each other. If you've already filed the forms to open your divorce case, but need to amend or fix them now, you should continue with this video and the workshop instructions. If any of these situations apply to you, you should contact the Self-Help Center to address the specifics of your case. You can contact us by email, phone, or live chat through the Self-Help Center website. Additionally, either you or your spouse must have lived in California for the past 6 months and Santa Clara County for the past 3 months in order to open a divorce case here. However, if neither one of you meets this qualification, you are still able to open a legal separation case today. Our court takes domestic violence very seriously. We recognize that some cases, perhaps yours, may include issues of domestic violence, whether it takes the form of physical abuse, financial abuse, emotional or verbal abuse, controlling behaviors or threats regarding children and custody, or immigration issues. The moment of filing and serving court papers in any kind of proceeding can be one of the most dangerous points in an abusive or controlling relationship, and domestic violence victims are often unaware of that danger. We can help you seek the kind of help you may require to ensure your safety at this point and going forward, so do not hesitate to contact the Self-Help Center for assistance. Please be aware that the forms require that you list a mailing address. If you do not want the other party to know your address, then you can use a mailing address for a friend or family member. You can also list a P.O. box. It is okay to not use your own address as long as you can receive mail at the address you do list. While a mailing address is required, you are not required to list your phone number or email address. To set the expectations, this video will go over general information about the divorce process and how to fill out your forms, and then the steps you will go through to process your divorce forms. If you are amending your forms, this information applies to you too. The first step is to watch this video and the following videos on minor children, if you have them, and your mandatory financial disclosures. Next, you will have several options to choose from to complete your forms, either online through interactive websites or by hand. If you would like your forms to be reviewed by the Self-Help Center before filing them, you may submit them by email to our office. Once your forms are ready, you will file them at the clerk's office, located in the Family Justice Center courthouse. Or, depending on which website you use to fill them out, you may be able to electronically submit them for e-filing. We will explain this process in detail later in the video. There are many more steps to finish your divorce. Filling out and then filing the initial forms is only step 1. There will be many additional steps afterwards, and it's important you move the case forward on your own. You will find helpful information here in our Next Steps After Filing video. Since you are the person starting the case, that makes you the petitioner. Your spouse is the respondent, since they can respond to the case you open. Once the case is opened, these terms remain the same forever. You will come across these terms many times in your forms, so it's important you understand them. This is a self-help center, meaning that you represent yourself and are responsible for all the decisions in your case and for completing all of the necessary steps, which we will explain shortly. The center cannot provide advice or strategy. What we can provide is information about the divorce process in California and the choices you'll be making. The Self-Help Center is neutral, so if your spouse comes to the center, they will also receive help with their paperwork. Regardless of how your case goes, it will not be completed until you write up the judgment documents for the judge to sign and receive them back from the court with the judge's signature and a file stamp. Please be aware that you are not divorced until the judge signs and the forms are filed with the court. Since you represent yourself, each time you come to the court, you should be sure to 1. Bring copies of everything you filed or that is important to your case. This is so you can look at them while you're working on your forms. 2. Understand the paperwork as you are filling it out before you sign it. And 3. Understand your next step before you leave. Remember that the court will not move your case forward. You are responsible for your own progress. If you find that you need legal advice, you should speak to a private attorney. It is essential when filling in names on your forms that you list everyone's full legal names, including for the children. You must always use the same version and spelling of everyone's names on every form, today and every time you come to court in the future. If you or your spouse use any other names, you will need to include these on your documents when you fill them out. This does not refer to nicknames, but to different legal names you may have used, such as on a driver's license, social security card, or immigration documents. You will put AKA for also known as, and put the additional names down, so your divorce judgment will reflect all the names you use. This can make a difference later if you need to prove you're divorced and you have only one name on your divorce judgment, but use other names too. For example, these are all different versions of the same name. Legally, these are all different people, so it's important to list each variation of the name as an AKA. The filing fee is $435 unless you get a fee waiver from the court. When you're filling out the online forms, you'll have the option to fill out the fee waiver forms too. If you fill out the paper forms, be sure to also request or download a fee waiver form. You can apply for the waiver if you receive public assistance, if you qualify as low income, or if you have other reasons you can't afford the filing fee. If you do not get a fee waiver, the judge may still let you pay a reduced fee or make payments over time. Be aware that if you don't make the payments as determined by the judge, your case won't be able to go forward and may be dismissed. There are 4 types of cases that would use the process that was just described. The first is a dissolution, commonly known as divorce. This is a case where you go from being married to being single. A judge can also make orders about custody, parenting time, support, and things you own or owe in your divorce case. You don't need to prove that you or the other person did anything wrong to get a divorce, and you don't need their permission or participation either. There is a residency requirement you must meet to start a divorce case. To file for divorce in this county, you or your spouse must have lived in California for the 6 months immediately prior to filing and in Santa Clara County for the 3 months immediately prior to filing. It is okay if only one of you meets this requirement. Legal separations aren't very common. They're like a divorce in that the judge can make orders about property and children's custody and visitation, but at the end of a legal separation case, you are still married and cannot get married to someone else. People most often file legal separation cases so that one spouse can keep the other on their health insurance if there's a pre-existing condition where they couldn't get new coverage. The employer will keep the second spouse on the other's health insurance policy because they're technically still married. Another reason people get a legal separation is for religious reasons. If you file for a legal separation and your spouse files a response asking for a divorce, then your case will become a divorce case. If you decide after you finish a legal separation case that you want a divorce, you'll have to start a new divorce case. Nullity, also called an annulment, is relatively rare. Unlike divorce or legal separation cases, you do have to prove certain facts in order for a nullity to be granted. Examples of those facts include your spouse still being married to someone else when they married you, or very specific types of fraud. In California, a short duration of marriage is not grounds for annulment. If this applies to you, you should contact the Self-Help Center or speak to a private attorney. Summary dissolution is a simplified and faster divorce process for people who meet special requirements. If your marriage was shorter than 5 years and you and your spouse have no children together, you may be eligible for summary dissolution. You must also be willing and able to fill out your forms together. If you think you may qualify, please see the summary dissolution video, which can be found on the Virtual Divorce Workshop page for more information. As part of your case, you can ask the judge to make court orders about issues such as child custody, the visitation schedule, child support, or spousal support. However, the judge will normally not make these orders until your case is being finalized, but often people cannot wait that long for court orders regarding children and support. For those of you who cannot wait 6 or more months for the court to make decisions about child custody and visitation, child support, or spousal support in your case, you should schedule a hearing. To do so, you can file what is called a request for order. A request for order gets you a hearing with a judge in 1 to 2 months, where you can ask for those orders to be applied while you are still waiting for your divorce to be finalized. If this is your case, you will need to complete the request for order forms, which you can find on the Self-Help Center website. Please make sure to complete this divorce workshop first and file your divorce forms before proceeding with the request for order forms. This is important because you must have an already opened case before you can file a request for order to request a hearing. If you have more questions about this process, please contact the Self-Help Center or see our website. Standard family restraining orders apply to each and every divorce or legal separation filed in California. These are not domestic violence protective orders, but rather restrictions preventing each spouse from doing certain things. You may hear them referred to as ATROs for short. For those of you starting a case, these will go into effect when you file this paperwork. If you are filing an amended petition, these orders are already in effect. They will remain in effect until your divorce is finalized. In a nutshell, the ATROs restrict both parties from doing certain things until the judgment of divorce or legal separation is filed. For example, neither party may change names on insurance policies, transfer title, or cash out accounts. Neither party may open or close accounts, including credit cards. Neither party may remove the minor children from the state of California, and neither party may apply for a new or replacement passport for the minor children. There may be an exception if a party obtains prior written consent from the other party or a court order granting special permission. This is a brief summary of those orders. Before filing your forms, you should read through the ATROs on the back of your summons for more details, because you are responsible for knowing and following them. If you have concerns about these restrictions, you may wish to seek legal advice from a private attorney. Lis pendens is Latin for notice of a legal action. As previously mentioned, when a divorce case is started, standard family law restraining orders require that both parties are restrained from changing the beneficiaries of any insurance or other coverage, including life, health, automobile, and disability, held for the benefit of the parties and their minor children. In some cases, a party may wish to notify their insurance company that there is a pending divorce case. By serving the insurance carrier with a notice of pending proceeding, you put them on notice that there are pending divorce proceedings and to not change the beneficiaries of the insurance until there is a court order or written agreement between the parties stating otherwise. The insurance carrier would then be required to notify you if there is a cancellation, lapse, change of the coverage, or change of designated beneficiaries under the policy. If you would like to notify your insurance carrier of your divorce action, you may contact the Self-Help Center for assistance. If you plan to submit your forms for review before filing them, let us know of any questions about lis pendens at that time. If you are the policyholder and would like to remove a lis pendens, then you have to provide the insurance carrier with a court order releasing the lis pendens, a final judgment of dissolution of marriage, or a written agreement between the parties releasing the lis pendens. If you would like more information about this, you should speak with a private attorney. You need to determine your date of marriage and date of separation. Hopefully, your date of marriage is something you already know. If not, you'll need to look at your marriage certificate. The date of separation is the date that you or your spouse communicated to the other spouse that the marriage was over and acted consistent with that going forward. For example, 1. You are not separated if you fight and leave, but return a few days later and go back to acting as a married couple. 2. You are not separated if you move out but are still trying to work it out. 3. You are not separated if you are going to marriage counseling because you are trying to work on your marriage. 4. Yes, you are separated if you're telling your spouse you don't want to be together and the marriage is over, even if you still live in the same home. 5. Yes, you are separated if you are telling other people that your marriage is over or deciding to start a divorce case. For many people, date of separation isn't important, but it could be for a few reasons. One is for dividing things that you own and owe, which we'll talk about later, and another is for determining spousal support. Spousal support, also known as alimony, is money paid by one spouse to another to support the spouse, not the children. It is to help the supported spouse learn job skills so they can support themselves and live nearly the way they did when the spouses lived together. It's especially important for spouses who supported the family and home and didn't work outside. The court can make 3 different types of orders regarding spousal support. 1. It can order an amount of support for one party to pay to the other. 2. It can reserve spousal support. This means the court is not ordering an amount right now, but that the court could at some point order support to be paid if one of the spouses filed legal forms to ask for it in the future. So it's $0 right now, but it's possible it could change. 3. It can terminate the ability of the court to award spousal support forever. This means closing the door to ask for spousal support in the future, so even if you are completely incapacitated, you cannot come back to the court to ask for support. You will need to decide which of these 3 types of spousal support orders you want to request for yourself, and which order you want to request for your spouse. These can be different. For example, you can request to reserve spousal support for yourself, but terminate it for your spouse, or vice versa. Spousal support is more complicated than child support. The court looks at a lot of factors when deciding whether or not to award spousal support. If you are asking for spousal support, you must prove the other person has the ability to pay it and that you have a need and deserve to receive spousal support. The court will also look at each of your earning capacities. What could you earn based on your work history, your education, and the current job market? The court will also consider length of marriage, as well as whether one person supported the other in going to school or building a career. The court also takes into account the ages and health of the parties. If you want to ask to receive spousal support, you can do that in your divorce petition. If you want to schedule a court hearing to ask for spousal support before your divorce case is finished, you should complete the Request for Order workshop on the Self-Help Center website after filing your divorce forms, in addition to requesting support on your petition. The state divides marriages into short-term and long-term marriages. Under 10 years is considered a short-term marriage. When the court is ordering support in a short-term marriage, generally the longest that support would be ordered is for half the length of the marriage. Now let's talk about long-term marriages specifically. 10 years or longer is considered a long-term marriage. In a long-term marriage, if support is ordered, it could be ongoing until the death of either party, the remarriage of the person receiving support, or until a judge makes another order. If yours is a long-term marriage and you ask the court to terminate the other person's ability to request spousal support in the future, you will have to justify, under the law, based on all the relevant factors, why the court should terminate support to them forever. This is especially important in cases where the respondent does not file a response. These are called default cases. In such cases, if the court is not satisfied with your justification, the court may order that spousal support for the respondent be reserved. This means that the door is open for the respondent to come back at a later date after the divorce to request spousal support. For example, let's say I am in a long-term marriage and I ask to terminate spousal support for both my spouse and myself, meaning that we will never ask each other for any spousal support. The court could deny my request to terminate spousal support for my spouse, or the court could reserve spousal support for my spouse, but the court must still terminate spousal support for me. That means my spouse would be able to return to court to ask me for support, but I could not ask it from them. If this is a concern, you have the option to ask at the beginning to reserve for yourself, even if you are asking to terminate it for the respondent. It is much easier to reserve for yourself now and then later give up your right to spousal support than it is to terminate for yourself in the beginning and later try to request it. We'll now go over the instructions you'll be following to open your case. The first step is to complete this video. Next, there are a couple other videos you need to watch before getting started on your forms. If you and your spouse have minor children together, your divorce case will need to include information about them. In this case, you will be deciding important issues like who has physical and legal custody of the children and visitation schedules. To clarify, minor children means any children under the age of 18. If you have adult children together, they will not be included in the divorce case. You must watch the video Minor Children, Custody and Visitation, which you will find on the Virtual Divorce Workshop page. If you do not have any minor children with your spouse, you may skip this step. In addition to starting your case, you'll also complete your mandatory financial disclosure forms. In the state of California, the declarations of disclosure are mandatory documents that married couples exchange to disclose asset, debt, and income information with one another. This process is a requirement of every divorce case, regardless of any possible agreements you and your spouse may have already come to. Even if you feel that you don't own or owe anything, or not very much, you still must complete these forms and this process before your divorce can proceed. Even if your spouse already has access to your financial information, or if your property is shared between you, you still must complete these forms. Similarly, even if you do not want your spouse to know your financial information, or you have not spoken in years, you still must complete these forms. You will need to watch the mandatory financial disclosures video, which you'll find on the Virtual Divorce Workshop page. This process can be quite confusing and complicated, so it is very important that you watch the video. If you plan on submitting your forms to the Self-Help Center for review, you will first need to submit a verification that you've watched all of the required videos. You'll find the verification form on the Virtual Divorce Workshop page. If you do not submit this online form, we will be unable to help review your divorce forms. As a reminder, there are 3 required videos. This starting a divorce case video you're watching right now, the minor children video if you have them, and the mandatory financial disclosures video for everybody. The other videos on the workshop page are optional, but we highly recommend you at least watch the Next Steps After Filing video once you've filed your forms. After watching all the videos, you will then complete your forms. You have a few different options for completing your forms. If you wish to fill them out online using an interactive program, there are 2 options. The first is the Law Help interactive site, which will produce completed forms in a PDF format, which you can download and print. If you would like our office to review your forms before filing, you will submit those PDF files to us by email. The second is the Guide and File site, which will also produce your completed forms as PDFs. If you do not want your forms reviewed by the Self-Help Center, Guide and File will give you the option to directly e-file your forms. This means you open the case electronically and do not need to come to the clerk's office in person to file your forms. You will need to pay the filing fee at that point though, so if you are requesting a fee waiver, e-filing is not an option. If you use either of these online programs, please be sure to save your login username and password, as you may need to log into your account later to make edits to your forms. If you would like to fill out the forms by hand, you can download the packet of divorce forms and a sample to guide you from the Self-Help Center website. Once you download, print, and complete these forms, you can either take them directly to the clerk's office to file, or scan them and submit them by email to the Self-Help Center for review. Finally, if you do not have access to a computer, internet, or printer, please contact the Self-Help Center to request the forms. If you would like your forms reviewed, please call the Self-Help Center to arrange a non-email review process. The Self-Help Center offers to review your divorce forms before you file them. While this is an optional service, having your forms reviewed by our staff decreases the chances of errors in your forms. If your filed forms contain mistakes, you may have to amend them later, which can complicate your case. Please remember that we cannot give you legal advice. We only help ensure your forms are properly filled out. If your case is particularly complicated or you need additional orders with your divorce, we recommend you get your forms reviewed so a staff member can help you directly. To get your forms reviewed, please go to the virtual divorce workshop page on the Self-Help Center website. There you will find the sign-up page to get your divorce forms reviewed. You'll provide some personal information about your case and upload your completed forms to this page. Once your request has been received by our office, the Self-Help Center will contact you about your next steps after your forms have been reviewed. Once your forms are completed, you will prepare to file them. If you used the Guide and File website to fill out your forms, you will have the option to automatically e-file them. Follow the site's instructions if you choose to do that, but keep in mind you will be required to pay the filing fee at that point in time. If you do not e-file, you will need to make photocopies of your forms. Before doing this, you will need to separate out some specific forms that do not need to be photocopied and filed just yet. You will notice that your printed packet of forms includes some blank response forms. These are for your spouse to use to respond to the divorce case. You should leave them blank and hold on to them, as these will need to be served on the other party later. The other forms to leave aside at this stage are the Proof of Service, FL 115, the Declaration of Disclosure, FL 140, and the Declaration Regarding Service of Declaration of Disclosure, FL 141. We'll explain what to do with these later. Next, you will need to sign and date all of your remaining forms. Make sure you don't miss any places requiring a signature. Next, you will make 2 sets of photocopies of the rest of your forms. That is, all of those you did not pull aside. In total, you should end up with 3 sets of your forms, the original plus the 2 photocopies. Each of these is necessary. Next, you'll bring your forms, the originals and the copies, to the clerk's office. The clerk's office will take all 3 sets, file stamp them, then return 2 of the sets of forms back to you. The court keeps the original set for itself. You will keep one of the copies for your records, and the third is for your spouse. If you're not asking to waive the court fees, you'll pay the filing fee then and get your file stamped forms back on the spot. If you are asking to waive the filing fees, you will submit your fee waiver to the clerk's office at this time. It may take about 24 hours to process the fee waiver and get your filed forms back. However, if you receive public assistance, your fee waiver should be approved immediately. If you have already filed your divorce petition, but it contains mistakes or you need to change information on your forms, you may have been directed to amend your petition. This means you redo the same forms you already filed and file them again. You may need to amend any of the forms you originally filed, but most commonly, it is the petition that requires fixing. The first time you do this, your updated petition is called a first amended petition, and the process is fairly straightforward. However, if you again make mistakes on your first amended petition and need to redo your forms one more time, you will need to request permission from the court in order to file a second amended petition. This means you have to serve the other party with your request for order or your motion, and then attend a hearing. To avoid this complicated process, it is very important that your first amended petition is done properly and without errors. We recommend that you seek the Self-Help Center's assistance in reviewing your forms to ensure that your first amended petition is completed correctly. You should proceed with this program for starting a divorce case and fill out the forms that needed fixing again. Make sure you alert the staff member assisting with your forms review that you have already opened your case and are amending your forms. You will still need to make the 3 sets of your forms and file them at the clerk's office again. However, it does not cost anything to amend your forms, so you will not need to pay the filing fee or fill out the fee waiver again. Afterwards, you will need to serve the other party with these new forms and possibly your old forms as well, depending on your case. Once you have filed your forms, there are many next steps to take. You must choose a person to be your server and have them serve the necessary forms on your spouse. Once service is done, you will need to take the next actions to complete your divorce case, which will likely take months or years, depending on how quickly you move your case along. These next steps are really important to having your case proceed, so it's crucial you understand them fully. When you are ready to file your forms, please watch the Next Steps After Filing video found on this webpage. This will ensure you follow all the requirements for service and follow through with your case. Please feel free to come back and rewatch any sections of this video that you need as well. If you have any questions, please feel free to contact the Self-Help Center.